Call the Honourable Member Keith Locke.
Thank you, Mr. Speaker. The Green Party disagrees very strongly with the previous speakers, including Leanne Dalzell, who's just said this is a good process. This is just reinforcing this Parliament's reputation, bad reputation, for being the fastest legislator in the West, where we can get hold of a bill that is, in this case, the Green Party. Just last night, an advanced copy of the bill. It hadn't at that point been tabled in Parliament. No member of the public knew anything about it, what it was about, its name, its content, anything else. In fact, the public wouldn't have any chance at all to find out about this bill until we start debating it in this House, and at the time we start debating it in this House, the bill and the regulatory impact statement are tabled in the House. So the public and any people who might be concerned with the legal issues involved in this are totally shut out of this process. If this is being rushed through in an hour or two here, anyone outside of this Parliament just doesn't know anything about it and cannot correct anything we may be doing wrong in passing this legislation. We don't know, for example, whether the Auditor-General has done a Bill of Rights audit on this particular thing, and we do know that we're going against what, at the moment in the Standing Orders Committee, there have been submissions by various institutions, including the Human Rights Commission, about the speed with which bills pass through this Parliament, insufficient time for people to make submissions, and they're talking about, how there's a problem when you've only got 4 weeks to make a submission and things like that. Here, the public is totally shut out of the process, and we have concerned citizens, lawyers, etc., holding seminars. A seminar, I think, was held in Wellington recently on the frequency of urgency, bills being rushed through, all of this problem in our Parliament. And now we're telling these people that a bill can just be rushed through in a couple of hours without anyone knowing about it and without the parties in the House knowing anything about it to do any research on it. They only find out about it the night before. So this is just, and the regulatory impact statement, we were given a copy of the bill last night. I couldn't get hold of the regulatory impact statement because that wasn't live on the website. I've only seen it just now after the discussion on the bill has begun. I don't know anything about the Attorney-General's report, if any, and there is discussion here about, well, we made a mistake in the previous bill. Well, what better way to make another mistake than to rush a bill through in a couple of hours without any real consideration by this Parliament, let alone the Select Committee, let alone submissions to a Select Committee. It's just totally, I was going to say unethical. I think it is unethical to proceed in this manner. And what is the problem? The problem, there's two levels. There's one level of whether or not we have made a mistake, and whether people who don't have a conviction but through the youth court but have diversion and things like that should have their identifying details not kept by the police. And there's an argument that even though that's been defined as a mistake, that situation could continue, because basically we don't want to label young kids with a record and they might be targeted, etc., etc. So there's a substantive debate involved here as well as a technical debate. But even if you accept the government's argument and Labor Party's argument there was a mistake and this needs to be corrected, why does it need to be corrected in this manner? Is civilisation in New Zealand going to collapse if there are one or two appeals as a result of the alleged mistake made here? Do you think that there's a whole lot of lawyers going to be running around like most people going through the youth court? They want to get it over with, they put it behind them. Why are they going to suddenly engage in get a lawyer, and the lawyer makes an appeal and they get their conviction scrubbed on the basis of this information being illegally held by the police for a period. I can't see it happening. And even if there were one or two cases, and I can't see really there'd be more than one or two, that is not a justification for rushing this through the Parliament as it is, for having a whole retrospective process, and retrospectivity is very bad, and people will rightly criticise us for that. Sure, this Parliament can make very serious errors that have gigantic consequences of billions of dollars and all sorts of heartache for people. This is not one of those. Let's look at the statistics they provide. I've just rushed through a bit of a reading of the regulatory impact report in the few minutes I've had before I had to get up and speak on this bill after the regulatory impact report was made available. And it says that there are 775 cases per year have their identifying details matched with a subsequent crime scene, and that some of these cases might have been based purely on a link between the particular IP evidence from the previous event to this event. Some of them, but nobody really knows how many appeals would be made on that basis. And as the previous speaker said, even if the identity information from the previous event was taken into account by the judge against the law in terms of the law as it's been the last couple of years, that doesn't mean to say that the conviction would be deemed to be invalid if there was, as is in most cases, other evidence for the commission of that particular offence. So, it's all a very murky area, and in fact one that should be looked at by the Select Committee. What's wrong with the Select Committee actually getting into this sort of thing? And then we find out that the police knew about this in October 2010. Jackie Blue, the National Speaker, has disclosed that. Well, how come there wasn't, if it is believed that there was a mistake made in the previous 2008 legislation, how come we didn't go through a considered process, the parties in this Parliament informed, go through a proper Select Committee process to correct this error? It's just not good enough. The regulatory impact report says if just 20% of these cases were appealed, it would be $20,000 per case, $6.2 million. I can't see that 20% of the cases would be appealed anyhow. But, what is the price of justice? What is the price of justice? What is the price of this Parliament having a proper select procedure of a bill through the House, including a Select Committee? This is not a case where we need to violate this process. The issue, the substantive issue, is very much debatable. Like, the Green Party would like to get a bit of legal advice on this. We're not all expert lawyers that can suddenly decipher the 2008 Act and this amendment and work out exactly whether it's right and what is we can't just do that in about the half an hour that we've been allowed in this Parliament from hearing the bits and pieces of the information from the other speaker. We do require the assistance of research staff, the parliamentary library, informed public, lawyers, debate with other parties in this House, proper Select Committee process, all of these things that are an essential part of our democracy. These have been violated. We did have the example of a similar event which was very distressing to the Green Party a couple of years back, where a bill was introduced into the Parliament on extended parole. We only knew about it at the time. It was deemed to be a technical bill. We only knew about it at the time it was introduced in a period of urgency, a National Party urgency. Then we found that there was a very critical Attorney General's report on that very same bill. The Green Party struggled to analyse it and we voted against it. The other parties didn't, but it was a big abuse of process for that to happen. Thank you.
I call the honourable